Good day, Dr. Nadia. My name is Ong Lin Li, student ID 0364723. In this video, I'll be discussing the legal dispute between State Aramika and State Botuna regarding a unilateral suspension of a bilateral treaty regarding a joint dam project. So now I'll be moving on to the first issue regarding the legality of State A's unilateral suspension. So under the Vienna Convention on the Law of Treaties, short form as VCLT, State A would rely on Article 60 when alleging that State B's failure to adhere to environmental safeguards under the treaty obligations constitutes a material breach. Under Article 60, Clause 3, Subclause 3, it states that a material breach of a treaty for the purposes of this article consists in the violation of a provision essential to the accomplishment of the object or purpose of the treaty. In simple terms, it means that a violation of an important provision of the treaty would constitute a material breach. If State A can prove that these environmental safeguards are central to the treaty's purpose, it may argue that B's conduct meets the threshold for the material breach. However, material breach is not easy to establish as the breach must go to the heart of the treaty and this is subject to a high threshold. However, even if material breach is proven, under Article 65, it imposes strict procedural requirements before any suspension or termination becomes legally effective. It provides that parties who want to terminate or suspend a treaty must go through a process for a valid termination or suspension of the treaty. The requirements are: number one, provide written notification of the breach and intended suspension. Number two, allow 3 months for objections. And number three, if any objection arises from the other party, peaceful dispute resolution must be sought before unilaterally suspending a treaty. These safeguards ensure that treaty obligations are not abandoned unilaterally or arbitrarily. Ignoring these requirements would undermine the principle of pacta sunt servanda and destabilizes the treaty system as a whole. The ICJ's decision in Gabčíkovo-Nagymaros project reinforces this position. Hungary, which had unilaterally suspended a dam treaty with Slovakia, citing environmental concerns, was found to have acted unlawfully for bypassing procedural mechanisms and failing to seek joint resolution. Applying this reasoning, State A's unilateral suspension without following any steps in Article 65 would likely be deemed invalid. So now I'll be moving on to the second issue regarding the defenses that State B has raised. So first of all, State B relied on Article 62 as a defense, which is about the fundamental change of circumstances, which is also called rebus sic stantibus. This provision means that a state can end or withdraw from a treaty only if all of these are satisfied. Number one, the circumstances that change were key reason the countries agreed to the treaty in the first place. And number two, the change is so drastic that it radically alters what the country still has to do under the treaty, which makes it a totally different thing from what was originally agreed by both parties. So the changes must be: number one, unforeseen; number two, fundamental; number three, essential to the treaty; and number four, it must radically transform the treaty's obligations. So for this defense to succeed, State B must show that the changes, namely those brought about by climate change, were unforeseen. However, this argument is legally weak. Climate change, while severe, is not unpredictable. Its long-term impacts have been widely studied, anticipated, and discussed since at least the late 1800s. In fact, as nearly as 1896, a Swedish scientist called Svante Arrhenius predicted global surface temperature has been rising and would continue to rise. Since then, awareness of climate change has grown steadily, particularly in the decades preceding modern treaty making. Furthermore, the ICJ in the Gabčíkovo-Nagymaros case has also made it clear that Article 62 is to be interpreted narrowly and cannot be used simply because compliance has become more difficult or inconvenient. As such, State B's reliance on the fundamental change in circumstances is unlikely to succeed, as the threshold for invoking Article 62 is extremely high, and the climate-related changes it cites were neither unforeseeable nor radically transformative in the required legal sense. The second defense that State B used was the United Nations General Assembly's resolution, which says that it recognizes access to clean water as a fundamental right. The UNGA resolutions are not legally binding and do not, by themselves, establish peremptory norms. According to Article 53, jus cogens norms must be accepted and recognized by the international community of states as a whole as norms from which no derogation is permitted. While access to clean water is undoubtedly an important human right, it has not yet attained jus cogens status under international law. There is no consistent state practice or judicial recognition affirming it as a non-derogable norm, unlike well-established jus cogens norms such as the prohibitions on genocide, slavery, or torture. Furthermore, even if such a norm were recognized, State B would still bear the burden of proving that the treaty's implementation, namely the dam project, directly violates that norm by denying access to clean water. Without clear and authoritative confirmation of both the norm's legal status and the treaty's incompatibility with it, State B's argument under Article 53 remains speculative and unpersuasive. Moving on to issue 3, on whether environmental obligations can evolve into jus cogens, overriding treaty provisions. So there's this Paris Agreement, which is a legally binding treaty on climate change according to UNFCCC, the United Nations Framework Convention on Climate Change. So this agreement was adopted by 195 parties at the UN Climate Change Conference in Paris, France on December 12, 2015. So under this agreement, the countries are expected to do their best to tackle climate change. This includes setting clear climate targets called NDCs, a short form for nationally determined contribution, and so they have to work together with other countries to tackle this issue. So these are really important rules and they already have strong support internationally. So now, according to the European Parliament's report in 2023, these climate obligations are not yet what we call jus cogens, but the report suggests that it is still possible that climate change rules could become jus cogens in the future, especially if all countries agree that they are absolutely essential and non-negotiable. So if that happens, then any treaty provisions that are against these strong rules can actually be invalidated, or parts of it can be invalidated as well, which depends on the situation. So this is based on international law rules set out by the International Law Commission. So there is this graph shown on a website called climate.gov, cited by United Nations themselves in a report called United Nations Secretary General's Call to Action on Extreme Heat. So according to this graph, it shows that the year 2024 has been recorded to be, number 1, the warmest year on record for both the northern and southern hemispheres individually. Number 2, the warmest year on record for land and ocean areas individually. And 3, upper ocean heat content was highest on record. So as such, it won't be long until the rules of climate change become jus cogens, seeing that the current situation of global temperature right now is quite high. So now I'll be moving on to the final issue regarding how do these three competing principles, pacta sunt servanda, material breach, and jus cogens, interact in this scenario. So when we're discussing the relationship between these three principles, pacta sunt servanda is where everything starts from. This principle is enshrined under Article 26 of the VCLT. Once parties have entered into an agreement, the agreement must be kept unless there is a material breach to the treaty of one party that renders the treaty or a certain obligation or provision from the treaty invalid, establishing material breach and leading to a suspension or termination of the treaty. Then comes in material breach under Article 60 of the VCLT. Material breach must be proven, and it is also shown to be hard to prove given the high thresholds established in the Gatchikovo-Nagimaros project. The ICJ made it clear that only violations going to the very object and the purpose of the treaty can amount to a material breach under Article 60 of the VCLT, and that procedural safeguards under Article 65 must also be observed. This illustrates the high threshold required to justify unilateral suspension. Lastly, the highest power that even treaty obligations cannot go against is jus cogens. If any treaty obligations goes against jus cogens, enshrined in Article 53 of the VCLT, it automatically renders the treaty or obligations invalid on absolute grounds. Tying this back to the facts of the situation, when State A and B have signed the treaty and entered into agreement, they must acknowledge the need to adhere to the treaty as per Article 26 of the VCLT, where Pacta Sunt Servanda provides that agreements must be kept and parties who enter into an agreement are bound by its terms and must fulfill their obligations in good faith, as established in the fisheries case. However, as in the scenario, State B did not adhere to the treaty obligations that they have agreed to. This would be against Article 26 of the VCLT, and thus State A can rely on Article 60 of the VCLT to prove that B's failure to adhere to the treaty obligations constitutes a material breach. However, the threshold for proving material breach is high, and even if proven, State A has not followed the procedures laid down under Article 65. But followingly, if the environmental obligations provided in the treaty are against a jus cogens norm, then that treaty obligation shall be rendered invalid and void on absolute grounds, which will make jus cogens being the one that cannot be challenged against. What can be challenged is whether the norm is considered to be a peremptory norm, where for it to be jus cogens, it must be universally accepted. So now comes the question, what could have State A and State B have done for their claims to have a higher success rate? Going to State A first, if State A was genuinely concerned about the State B's failure to comply with environmental safeguards under their treaty, it should not have unilaterally suspended the treaty. Instead, it ought to have followed the proper procedure under Article 65 of the VCLT. Firstly, to issue a written notice and then allow State B 3 months to respond, and if State B objects, then they should engage in a peaceful dispute resolution. By doing so, State A would have respected international law and strengthened the legitimacy of its position. Alternatively, it could have proposed amending the treaty under Articles 39 to 41, or even referred the dispute to arbitration or the ICJ. Now going to State B, rather than relying on their defenses like jus cogens and fundamental change on circumstances, which are difficult to prove in this context, it could have taken a more constructive approach. For example, it could have objected formally under Article 65, triggering a dialogue and legal review process. It might also have proposed to renegotiate or update the treaty's environmental obligations in light of new scientific developments. By showing a willingness to cooperate or demonstrate partial compliance, State B could have avoided the appearance of a material breach and maintained its standing under the treaty. So is there a potential reform for the environmental obligations and climate change currently? Because I've seen so many news about how fast our global temperatures are rising right now, and is genuinely so concerning to me. Therefore, I believe it is crucial that international law evolves to reflect the commitments already embraced by the global community, most notably through the Paris Agreement. This landmark treaty, adopted by nearly every nation, represents more than just political consensus. It affirms that environmental protection is a shared, urgent responsibility. To give real legal effect to this commitment, environmental obligations should be recognized as erga omnes, meaning owed to all, and then from there gradually elevate to a jus cogens status, placing them among the highest norms of international law. This would empower states to take decisive environmental action without fear of violating treaty obligations. If the Paris Agreement is to be more than words on paper, the international legal system must rise to meet its ambition, which is to ensure that the protection of our planet is not just encouraged but legally guaranteed. In conclusion, the dispute between State A and B highlights the balance between treaty obligations and evolving principles of international law. While State A may claim a material breach under Article 60 of the VCLT, its unilateral suspension is legally invalid due to its failure to follow the procedural steps under Article 65. On the other hand, State B's defenses are unconvincing. Climate change is not unforeseen, and access to clean water, while important, has not yet attained jus cogens status. It is also true that environmental obligations may evolve into jus cogens norms, and if it does, it will override treaty obligations. Ultimately, I believe that this question is for us to raise awareness regarding climate change issues right now, because it is a big issue, and I don't think a lot of people are taking it seriously. So this scenario really underscores the need for international law to evolve alongside global environmental imperatives. The Paris Agreement reflects a near universal consensus that climate protection is a shared duty. To give legal weight to this commitment, environmental obligations should be recognized as erga omnes and then gradually elevate itself to a jus cogens status. This would empower states to act decisively in defense of the planet without fear of breaching outdated treaty provisions. If we are to meet the ambitions of global climate agreements, the international legal system must rise to the challenge, ensuring environmental protection is not just encouraged but legally enforceable as well. That's all for my video. Thank you so much for watching. Goodbye.